This is the Lulich Corner. I'm Jordan Lulich, and today I get to sit down with Susan Chesnutt, a local esteemed family law attorney from Vero Beach. So Susan, I really appreciate you coming in, taking your time to share your wealth of knowledge about family law for an area that I know enough to be dangerous about. So thank you.
You're welcome. I appreciate the opportunity to come and talk about what we're going to talk about today.
I'm excited to dive into it. And I think that, people have heard different family law terms thrown around. They've heard 50-50 for Florida. They've heard equitable distribution. And so I think today, a point is to shed some light for people that maybe they've heard a little bit of information, but now we've got you as an expert coming in that can really clarify and say, hey, this is what applies in Florida. And so that for those first couple terms that I mentioned is, 50-50. Oftentimes, people understand in Florida, if they get divorced, it's going to be divided up 50-50, or that there's an equitable distribution. So is equitable distribution the same thing as 50-50, or are they different? Or how does that work when a court's analyzing how to divvy up the assets of a married couple?
Okay, so the court's first task is to determine whether or not there was a prenuptial agreement that would control the division of the assets and liabilities that were accrued during the marriage. That could also be done by a postnuptial agreement if we were able to use that in the process. But the task for the court under 61.075 is to divide all of the marital assets and liabilities into two categories, and they must divide it into non-marital and then marital. The burden is on the spouse who's claiming that the asset or the liability is non-marital to prove that it's non-marital. That's usually applying to assets. Nobody wants to ask for the liabilities to be non-marital.
That wouldn't be beneficial.
Not usually how they go about it. But in order to do that, the court has to then determine, based on these assets, what's left in the marital estate. And I think you asked me, does equitable distribution mean equal? Not always. We're a court of equity when we're in family law. So it starts with the court trying to divide the assets and the liabilities equally. But there is a list of factors within 61.075 that talk about it's A through J, and it talks about certain things like contributions of the spouse to the marriage for the homemaking roles, and contributions of the spouse to enhance the assets and pay off liabilities of another spouse. Like all of those different things are contained within that. There's also an opportunity that if equal is not quite fair, because it's a court of equity, then you can ask for an unequal distribution. And that would be something in what we're talking about that could happen to offset some of the issues when you have a personal injury settlement involved in a divorce. And then you also have, did the personal injury settlement happen before the divorce and is part of it non-marital? And then what happened to the money? Mm-hmm. Then you also have, did it occur while they were married? Right? From the date of marriage, either to the date of filing or the date of separation, or did it occur after the date of filing and the date of separation? And the entitlement changes with each of those distinctions.
So there's a lot of analysis that really goes into whether it's, an asset or a settlement occurred before or after, or whether property is marital property or it's non-marital property. But I think that what I've heard you say multiple times is equitable, equity, fairness. And I think while it may not be presumed 50-50, I think a court's looking to try to be fair for the parties. And I think that's really the message that I've got from you. Yes. in the court trying to divvy up these assets. Because it sounds like it could be a very challenging job for the attorneys involved, for the court involved. Sounds like it could be very challenging because you've got liabilities, you've got assets, maybe you have settlements right before divorce. And so when you start to break down this analysis, what's marital property? Like what on the surface level?
On the surface, a very easy explanation would be any piece of anything, whether it's half the money your spouse earned during the marriage for their dollar on their paycheck, you're entitled to half of that. Any pension growth that occurs, during a marriage, even if there's a non-marital house and then a couple moves in together, they live in the marital house, in the non-marital house that was the other spouse's premarital property. If there's contributions made to the house from marital funds, then there's a coverture fracture. Yeah. So it is very difficult, but the courts always try to make it as equal as possible. And what that often results in is having to take a little bit from this side that may not be marital to compensate for some of the things that happen within the marriage that we'll discuss in a little bit, especially with PI settlements.
And so with a prenuptial agreement, if someone has a prenuptial agreement that's signed before they get married, then that's for sure not going to allow the court to take that non-marital property and offset it, or what is that impact exactly that prenuptial agreement
The prenuptial agreement has to have the specifications on what happens if this is acquired during the marriage, how we're going to divide it. Most prenuptial agreements say what I bring into the marriage is mine. Anything that we jointly sign or becomes an agreed debt, then that would be something considered in the prenuptial agreement. Like if they buy a house together, then that one piece of property would not necessarily be considered non-marital, but there's always some sort of guideline in the prenuptial agreement. The thing about personal injury settlements is I don't know that they're anticipated as often as they should be in prenuptial agreements. And, in practice, that's something that needs to be done a little bit better. But more specifically, when you have those agreements, they control, but there's a lot of other analysis that goes into them as well, how they were entered into, the financial disclosures that were made beforehand. So they're not necessarily a guaranteed protection.
Yeah. And I think, we were looking at one for a client. They brought in their estate plan and they had a prenuptial agreement. But in the prenuptial agreement, there was no direction given to the other party to go seek an attorney and obtain independent legal counsel.
Yes.
And so just printing off a prenuptial agreement from online, that's not the best way to go about it, because it's a lot more complicated than I think people realize. So someone like yourself would really help make sure that a prenuptial agreement's valid, because that could cost someone hundreds of thousands of dollars. I mean, that's huge.
It is, and it's to protect you the best.
Right.
When things don't quite work out, you have a plan. The problem with, I would say emotionally, when people are in divorces and they're having these issues over dividing assets and liabilities, is that there's so much emotion that's kept with that. Yeah. When you have something like a prenuptial agreement, it's a contract, and it kind of takes a little bit of the emotion out and gives a lot more direction. It may not have everything you need, but at least it covers some of what you're dealing with.
Covers some of the bases. Mm-hmm. Makes it a little bit more logical than emotional. So for our clients that settle a personal injury case during the scope of their marriage, is that considered, that settlement money, those settlement proceeds from, whether it's a slip and fall or whether it's a car accident, and they settle those with the insurance company and have some type of settlement check from the insurance company, mm-hmm. How is that treated? Is that considered marital property, or would that be non-marital property?
The general rule is that a personal injury settlement for an injured spouse would be non-marital property. It's not automatic, because that spouse still bears the burden of proving that it's a non-marital asset, right? They got to get past that first hurdle first. But we know with personal injury settlements that usually those settlements are for, lost future wages, mm-hmm. The payment of the expense, pain and suffering, the expenses of their own medical bills. Those are specifically for the injured spouse. So I think your question was, how does having a PI case during a divorce affect the outcome? It really depends on whether or not that non-injured spouse was listed as a party on the lawsuit. That gives them a lot more. Which
sometimes they are. There's a remedy in Florida law for loss of consortium. So, mm-hmm. If your accident causes some type of strain on your spouse, and they're having to do more chores around the house, or if they're affected by your disability or your inability to walk the way you used to, well then, there's some proceeds that are going to go for a spouse for a loss of consortium.
Absolutely. That, and then also if there were any lost wages during a period of time that the marriage was intact, then those lost wages, the non-injured spouse is also entitled to a portion of, because those were wages for the marriage as the marital pot, right? Yeah.
I think because oftentimes when you have a personal injury settlement, you're really not depicting specifically how much each of these are itemized out on.
Right.
So from your perspective, if you see a personal injury settlement statement and you just see one lump sum, that could create a lot of difficulty in you trying to analyze and trying to break down the amounts. So I think communicating with your personal injury attorney that you are contemplating a divorce, and your personal injury attorney working with a divorce attorney to make sure that you're taking the necessary steps to make sure that that analysis is possible or feasible. Because what happens if you just have one lump sum? I'm sure you've seen it before.
I have seen it, and I've litigated it twice, and it's a nightmare.
Yeah.
When you have one lump sum, it's a nightmare. And one of my recommendations for if a personal injury settlement or injury accident occurs during the marriage, but before any equitable distribution is even determined, that person should be immediately working with their personal injury attorney to make sure that if there is any of those specifications that you can lay out in a settlement that potentially you could, and then also so that they're working closely as co-counsel with the divorce attorney that you are working with so that everyone is on the same page for the benefit of the injured spouse.
Yeah.
Right?
I couldn't agree more.
I thought that was very important.
Yeah.
You can't... It's two lanes that merge.
Right.
So you've got to have two experts in that lane, because I'm not an expert on personal injury as much as you're not an expert on divorce.
Right. And it really takes communication from the client to both sides. Like, hey, I've got this personal injury case going to you, or hey, I'm contemplating, it's confidential, but I'm contemplating a divorce. You know, I've already begin conversations with someone like Susan, and it takes communication from clients because we don't know what we don't know.
Absolutely. We do not know.
Knowledge is power in order to help facilitate the synergy between both of the advisors. But I think it can become really complicated because one of the things you said previously when we were talking about marital property versus non-marital property is you were talking about certain circumstances when non-marital property can become marital property.
Absolutely.
And you use an example, maybe a non-marital home where a couple moves into and then starts making payments for that non-marital home, then it becomes marital. Well, what about in the context of a personal injury settlement, right? So, you know, a client settles a case for $200,000, and then they take that $200,000 and they use it as a down payment for a marital home, or they start to use it and cover mortgage payments, or they renovate their kitchen, or like the list goes on and on and on. What happens?
Well, the truth of the matter is that that's a necessity in people in the situation that you represent, because they may be injured, right? And then it may take several months to get any assistance as far as their medical expenses and things like that. And it's expected that the marital funds will be used to help with those medical expenses. There's also situations where what you mentioned, where the injured spouse will use part of the personal injury settlement to pay a large portion of the principal payment on a house that they may own jointly. Maybe. They pay it down. Or they pay off a marital debt or a student loan of their partners or whatever it is. You have to be very careful as someone receiving a personal injury settlement what you do with your money. My advice would be that you would put that money into a separate account, even though it's during your divorce, and it is still considered in the analysis of whether it's marital or not, because it was acquired during the marriage, that account and that money. If you keep it separate, it makes commingling not so possible. And commingling is where you take this money and do exactly what we've been talking about. You kind of gift it to your marital expenses. You gift it to your standard living, right? So in those situations, you have to use tracing. You have to overcome the commingling argument. You have to overcome an interspousal gift argument when you just decide to pay off their student loans with that money. And there are ways to recoup that, but it does take a lot more effort than if you had kept the funds separate and not paid marital expenses with it, although some people are forced to. But every bit of that can be traced.
So there are ways to recoup it, but it becomes more difficult. So if I were to use $50,000 out of a $200,000 settlement towards paying down a mortgage for a property that I jointly own with my spouse, is just the $50,000 then that effort has to go to recoup that $50,000, or does the entire $200,000 become, considered or presumed to be marital property?
Only the amount that was commingled becomes the concern of whether or not it's marital property. Only the commingled amount or the gifted amount becomes that what is at issue. In order to recoup it, you have to go through great lengths.
But like a home, a non-marital home, maybe a home that husband owns before they get married that husband and wife move into, then would the entire equity in that home be considered marital property?
No,
if they move
not
into
necessarily.
It? Okay.
That's two different analysis. Specifically, one contains a coverture fracture of what marital funds were expended on the pre-non-marital asset, and whether it paid down the principal, it improved the value of the property. The spouses whose half of their money from the marital pot was used to pay that is going to be entitled to some of that, but it doesn't open up the entire settlement itself. But to go back to your question, they would be focused on recouping that $50,000 by using tracing.
Okay.
Because you can see we live in an electronic world. Everything is, the check gets cashed, it gets deposited into an account. The account shows the transactions that go here, there, and everywhere. And if you can show from the settlement to the house, it can be considered a gift. It could be considered, I had to pay these expenses for the marriage because we didn't have it. And then you can try to recoup it. It gets messy.
You've mentioned, I think, 2 or 3 times now this concept of tracing. So,
yes.
So what exactly is tracing in the context of a divorce?
So any divorce, especially if contested, there is a rule of discovery where you have to disclose individually, each of you as a spouse, all of your debts, all of your liabilities, right? And that includes, all of your assets and your liabilities. That includes stocks, personal injuries, bank accounts, inheritances. Every bit of your financial stuff is supposed to be in your financial affidavit. So through the course of discovery, you can request the documents that are going to show how you can trace. And it's all through the discovery process. And that would be bank statements, credit card statements, receipts for payments of certain things. Like you can trace it. And when I say tracing, the concept more is going from the beginning of the transaction of leaving the non-marital spouse's pocket. You trace the steps electronically because cash is almost impossible, to where all the money went, and then make an attempt to recoup that back.
It's almost like a forensic accounting.
I was going to say at the end of the podcast that it becomes very difficult once you have to overcome the commingling, because once it's commingled and it's money, it's so fungible, it goes where it goes. It can be traced, but the more that you put in, let's say you've got a $500,000 personal injury settlement and you paid $20,000 for a roof, you pay a little this, you pay a little that. The more you do those things, the more it requires more of an expert to do the tracing analysis, and that is a forensic accountant.
Yeah.
Yes.
And that gets very expensive.
And it gets very expensive. Yeah. And a lot of people, I don't know, the personal injury settlements may not be worth all of that forensic analysis, right? They may not have all of that. They don't have such a sum that they want to spend the money trying to recoup money.
Yeah. Just keep it separate.
Yes,
I think
keep it separate is my biggest piece of advice, and only spend it on the injured spouse. Yeah. And, there are the loss of consortium things in those type of, claims that are made. And there is, in those factors that I mentioned to you, the other spouse's role can be considered in caring for this other individual that was injured. So those things get taken into consideration too.
So if you're contemplating a divorce and if you're going through a personal injury case, I think the best thing you can do is communicate to your divorce attorney, communicate to your personal injury attorney, and connect the attorney so that they can make sure that they properly plan and take necessary steps to make sure that not additional work is created, but that there's protective measures that are taken and put into place to make sure that this doesn't become an issue like we're talking about, and an analysis doesn't have to happen like we're talking about. So, Susan, we are out of time. I really appreciate you coming on. I'm sure people are going to have more questions from this. So what's the best way to reach out if someone had an additional question about what we talked about today?
I've actually litigated this issue quite a few times, and if they wanted to contact me to get some information, they can visit my website, thechesnuttlawfirm.com. They can contact the office, 772-492-3330, and speak with one of the intake staff to get
in contact with you.
Yes, sir.
Well, we appreciate you listening. Thank you for your time, and we'll see you next time. I'm Jordan Lulich, and this is the Lulich Corner.